The following program is being brought to you on the Voice America Business Channel. For more information about our network and to check our additional show hosts and topics of interest, please visit voiceamericabusiness.com. The Voice America Talk Radio Network is the worldwide leader in live Internet talk radio. Visit voiceamerica.com. The views and ideas expressed on the following program are strictly those of the host or guests and do not necessarily reflect the views and ideas held by the Voice America Talk Radio Network, its staff, and management.
Welcome to Strategies for Financial Survival with Michael Figueroa. When financial adversity hits, and it very well may hit you, it's those that educate themselves and use their skills that will survive, no matter what field you're in. Now, here's your host, Michael Figueroa.
Good morning, everyone. So today, we're going to talk a bit about bankruptcy law. And what I'd like to do is give a little summary of what we've gone through and how and when this issue might come up. Today, my guest is Jeffrey Neff. He's been a bankruptcy attorney in Tucson for a number of years. I'm going to introduce him in a minute, and he'll talk about his resume. And so the issue today will be how you deal with potential problems. So before we start, let me introduce Jeffrey Neff. Jeff, will you give a little bit of background of your expertise and time as a attorney in the bankruptcy and real estate field?
Sure, absolutely. Well, first of all, thank you very much for having me on your program today. It's an honor to speak to your guests and listeners. And I've been a bankruptcy attorney probably, I would say, ever since I've been in practice. I was very interested in the commercial field of law, including real estate. I was certified as a real estate specialist in 1986, and I've been recertified by the State Bar of Arizona since then. Now, everybody seems to know, and especially from recent experience, have seen that what you have, when you have real estate, you're going to have bankruptcies. Because it's there are cycles in real estate and cycles in business, and a lot of times real estate is illiquid and people are stuck with more debt than they can handle. So I've done a lot of Chapter 7 work, I've done Chapter 13 work, and I've done business bankruptcy, which is usually Chapter 11. Now, Jeff, give your contact information, which I'll have you also give again at the end of the show in case anyone wanted to contact you. No problem. Well, first they could contact me by calling my telephone number. I'm in Tucson, and it's 520-722-8030. I also have a website, nefflawaz.com. where people can find me. You can also Google my name, Jeffrey M. Neff, Tucson attorney, or real estate attorney, Tucson, and I come up pretty high on those rankings. And I'm with a small firm, my own firm, Neff and Griffith, and we have Deborah Griffith is my law partner. She does litigation and rezonings, and Amanda Fife helps me in the bankruptcy area. Very good. So let's go to scenarios. What we've talked about on the show so far is, especially in regards to my expertise, was real estate. But you could utilize some of the examples I gave in regards to almost any business. And again, Jeff, since you haven't been on the show, I'll give you a little background on, and everyone else, what we were talking about. So the typical situation is that someone is laid off, their business failed,
and they have to go out and try to figure out how to make a living. And so in the scenarios we've been going through, they're looking to maybe buy and sell real estate, find a investor, go out there and hunt for the transactions, and put a team together and basically start a business that's buying, renovating, and selling real property. And like I said, this could be in almost any type of business that somebody may want to do. Retail, restaurants, service-oriented. So in regards to that, you're going along, your business is doing well, and the market changes. Or in a lot of scenarios, the business changes due to the economic conditions, and or let's say that you had signed for guarantees on bank loans in the past or credit card debt in the past. And of course, another scenario, of course, is that you signed for mortgage loans on your home, and now the home is upside down, meaning that the debt is greater than the value of the property, and it's in foreclosure, and that foreclosure may come down in the next 10, 15, 30 days, and you'll lose your home. So in these scenarios, what I have seen, and I know you have seen, is the person sees the problem coming, and they can't pay their bills because of the situation of not having enough cash flow coming in from whatever source. And it could be their salary, it could be their business, and they come to you and they say, Mr. Neff, what are my options? And here's my factual scenario. My home is in foreclosure, and it will probably go to sale on February 1st. I have a lawsuit pending for a credit card debt of $20,000. I have a bank credit line for my business that is in default, and they filed a lawsuit. And then I have default on my lease at my business, and that landlord may file a lawsuit. On top of it, I have not been able to pay my employer taxes to the IRS, so the IRS has sent a demand letter saying if you don't pay your withholding taxes, we're going to seize your account. Now, the other side of the fence is I have a retirement plan or IRA that has $50,000 in it. I have a rental house that is worth $70,000 and it's free and clear. I own a 1/3 interest in an LLC that owns my retail business, and I've got about $20,000 in cash. So that's my fact situation, and I've got some personal property, and throw in that I have a free and clear automobile worth about $15,000, and a lease on another automobile for well, it doesn't matter. It's a lease on another automobile, and a car that I guaranteed for my son that the debt is higher than the value of the car. I think this is kind of a typical scenario that may walk you. So what's your analysis going to be? What type of bankruptcy? Is this person best to file a bankruptcy? What are the options? What does a bankruptcy do for him versus not?
Well, the first thing you'd want to do is make an evaluation of whether you have a financial trauma that the person is experiencing, or you're just so far gone, you might as well call it a financial death. So if you are looking at, so you would take a look at the three different types of bankruptcies that you could apply to this situation. The first is a Chapter 7 bankruptcy. That's a full liquidation. That means that everything that you have would be sold to satisfy your creditors by a trustee, with the exception of certain exemptions. And in order to qualify for this, you must meet what's called a means test. And the means test, it requires you to make so little money that you can't reasonably devote any of your net disposable income to paying back your creditors. So you basically have to be on death's door financially in order to file that kind of a bankruptcy. So that's the first type of bankruptcy. The second type of bankruptcy would be a Chapter 13. Now, that means that it's a working person's bankruptcy, or it's aimed for debtors that have a certain amount of disposable income that they can devote to paying back their creditors.
Now, Jeff, that generally seems to fit people that have wages that they are collecting from an employer that they do not own, such as a government entity, Raytheon, HP, some company like that, Walmart. Is that correct?
Yes, but it doesn't exclusively apply to them. It's any debtor with regular income. And that can be a commissioned salesperson. It can be a, let's say, commissioned salesperson, a real estate agent. It can also be a person that has a business. As long as the debts in the business that are guaranteed by the individual don't exceed $1 million, you're fine. Otherwise, you have to go over into a Chapter 11. Now, Chapter 11 is a true business reorganization, but I don't think that I'm going to make the assumption that a Chapter 11 business reorganization is not applicable to this particular factual situation. So the first thing someone does when they come to my office would be to do some bankruptcy pre-planning. Bankruptcy pre-planning consists of taking as many assets as you can that are non-exempt and then converting them into exempt assets. Now, what would that be? Well, money in an IRA and most retirement plans, again, I say most because some are exempt, most are exempt, but you'd have to look at what particular plan the person had. If you can make contributions, for instance, of some of that $20,000 in cash to pay those IRA or to pay down your mortgage or something like that, you're in a good position for bankruptcy, because you would not want to file bankruptcy with $20,000 worth of cash in the bank. That would simply be devoted to paying your creditors, and you would gain no benefit of it. So what you need to do is pay down, for instance, some of the most common exemptions are a house. In Arizona, you can have $150,000 of equity in a house. An automobile. In Arizona, if you're married, there's a joint exemption. Each individual gets $5,000 in a car, or they get $10,000 in one car if you are married. So, and then you're able to keep your IRAs, and the personal property I can go through the list of exemptions. Each state has a different list of exemptions. But in Arizona, generally you can keep pretty much your furniture that you have in your home, all your kitchen equipment, and other yard tools, everything you really need to run a home.
Now
You're also allowed to keep business items of business property for your business and profession, and many times the computer will qualify under that. Yes, sir.
Jeff, I'm going to go over some of those questions because I see a lot of people that when they talk to me, they have this exempt or that exempt, so I'll talk about that. We have to go to our first break here for a minute or so, and we'll come back and talk about these personal exemptions. Thanks.
Thank you. No problem.
We're always talking business. Talk to an expert. Call now toll free 866-472-5790. That's 866-472-5790. Voice America Business Network.
At Intuitive Strategies, LLC, we provide services to our clients that help them develop a strong education in business. And we also help them to develop a strategy that will allow them to turn their skills into a profit, protect their business and personal assets, and plan for a successful retirement. Our consulting and structuring services include business analysis, budget analysis, management analysis, ability to raise capital from investors, tax planning to minimize tax liability under code, as well as legal structure to protect business from frivolous lawsuits. Intuitive Strategies also provides document preparation services, such as business structuring documents, documents that establish an entity, management agreements, retirement plans, estate planning, wills, and trusts. Let Intuitive Strategies help you with your business. Visit intuitivestartup.com or call us in Tucson at 520-425-8759. Visit intuitivestartup.com today. When it comes to business, you'll find the experts here. Voice America Business Network. You are listening to Strategies for Financial Survival with your host, Michael Figueroa. If you have a question or comment about the program, please send us an email to support@intuitivestartup.com. That's support@intuitivestartup.com. Now, back to Strategies for Financial Survival.
Welcome back, everyone. We were talking to attorney Jeff Neff regarding personal bankruptcy issues, and one of the things we were going on was personal property. I know, Jeff, a lot of people like to know what personal property is going to be exempt and about how much. So the typical things that come up, of course, are the automobile you mentioned. Let's say a gun, a wedding ring, things like tools for their trade. So cover some of the main things that you see and how that's disposed of or dealt with.
Well, let's go back to your example. A person has $20,000 in cash. The best thing to do with that $20,000 in cash would be to create equity in a home or to pay off an automobile up to the exemption amount. Your automobile is one of the most important things. The value of that automobile cannot exceed the net equity value, meaning the amount above a lien on the prop cannot exceed more than $5,000. Generally, unless they're the Hope Diamond or something like that, you can keep rings, jewelry. You can keep items of personal property. You can keep tools necessary for your business. Those are general exemptions, and that's in Arizona. Each state has a separate list of exemptions. No state that I know of has adopted in full the federal exemptions. So if you want to go through the assets we have here, I would recommend on the automobile that you're saying is worth $15,000. if the person is qualified for Chapter 7, you can either borrow some money on that automobile and put it into an exempt asset, or what you can do is repurchase from the trustee any equity you have in any exempt items. I've been pretty successful at that. The trustees take the assets at liquidation value, and they have been rather favorable to debtors because they like to make the let's call it the quick cash from the transaction to distribute to creditors, rather than trying to realize full absolute value to contribute to creditors, because that takes so much time. A home would have an exempt value of $150,000. You had spoken about someone that has an interest in an LLC, and the question is, how much of an interest do you have, first of all, and second, the relation of the parties in the LLC to you. If you have a 1/3 interest in a limited liability company, that's not liable to be touched by a trustee, because there would be other, I will call it, members of the LLC. So long as that other members or members are not in bankruptcy, say your spouse and you file bankruptcy as well and you both have an LLC, you wouldn't have any problems retaining that interest. It's not really touchable by the trustee, and it has very, very little value. I don't know of any trustees that really have gone after LLC interest in a 7. If you have a free and clear rental house, you may have a problem, because that asset in a Chapter 7 would be liquidated. Now, what would happen to your, on the creditor side of things, what happens? In a Chapter 7, your credit card debt would be discharged. Poof, it's gone. Your liability for the lease that you were talking about on the store, on the defunct business, poof, it would be gone. The bank credit line, poof, it would be gone upon filing. Now, I'm sorry to say that the IRS debt would not be gone. You would have to make some sort of compromise with the IRS, and that is definitely another show, because that is requires some expertise, and it's expertise that falls outside the bankruptcy court. The government does not discharge the debt to itself or to other government entities, such as the state of Arizona. Now, your proof of filing might allow you to go to the IRS and say, I am really destitute, I am bankrupt. You cannot take anything from me. Look at my schedules, and I'll compromise, and you could get an offer and compromise. But again, that's another matter. You outlined a scenario where the home would be in foreclosure.
Correct.
Well, in a Chapter 7, a home that is in foreclosure does not get, it is stayed. The foreclosure is stayed. In other words, stopped. But after the administration of the Chapter 7, or if the lender on the home goes to the court and moves to remove it from the bankruptcy, and that's called filing a motion to lift the stay, then they could get that foreclosure to proceed and could continue the foreclosure. That's in a Chapter 7. In a Chapter 13, if you're eligible to file one, and anyone can elect, even if they're not eligible technically under the means test, you are allowed to basically lump all your debts and pay them over a period of 5 years, and what is not paid is essentially discharged. So let's take a scenario about the home in foreclosure. And let's say that let's take numbers on these things. Let's say you have $150,000 of equity in your home. You have a bank credit line for $20,000. Your lease liability is $5,000, and your credit card debt is $5,000. The IRS debt is, let's say it's $10,000. So, and you have your rental house. And you have your automobile. What you would be able to do is those have to be prioritized. You have a home in foreclosure. Let's assume that it is $6,000 behind in its payments. You would be able to pay over the period of the plan enough money to pay the arrears on the house, and you must pay its current payments. So you would add, it's a 60-month or 5-year period that you typically use. So you would have to pay an extra $100 a month toward your house to make up the arrears. You would then have to pay the IRS debt. You could select an amount to pay. It would not have to amortize it in over the 5-year period, but then you would be stuck coming out of bankruptcy after 5 years with an IRS debt. But the other debts that you did not pay, such as the credit card, the lease default, the bank credit line, let's say you were able to apply through the formulas, and these formulas are computerized, so they're pretty easy to find out. You were able to pay $100 a month on all of those debts. Then you would have discharged $30,000 worth of debts for a payment of $66,000. So it's a way of paying off your creditors at a discounted amount. The only problem that you have with a Chapter 13 is that it does continue for 5 years. You must make the payments, and if you do not make the payments, you either fall into a Chapter 7 and are liquidated, and you would lose your home in foreclosure, or you are in a situation where you are out of bankruptcy and the case is dismissed and the creditors can then attack you. Now, there is a great thing that you can do in bankruptcy and in a Chapter 13. If you have a car that's worth, let's say it's worth $10,000. That's an exempt amount. And the lien on it is $20,000. In other words, it's a fairly new car. You can go to court and basically scrape off $10,000 of that lien and make it an unsecured creditor, which you would then have to pay a little bit of. But it would fall into all the other unsecured creditors. So you are able to scrape off the amount that is unsecured on that creditor's interest on your car. There's another, it's called lien stripping. Now, Congress has seen fit to take first liens and make them exempt from lien stripping or from being scraped off. So if you have a house that's worth $70,000 and you have a first mortgage that is $100,000, you're stuck. You cannot scrape off that $30,000. But if you have a house that is worth $70,000 that has a $100,000 mortgage but has a $50,000 second, actually, this is a scenario I actually had. It had a $100,000 second on it because at one time it was worth $250,000. Now it was actually worth $70,000. We can actually totally remove that second lien on the house because it is not secured at all by anything and has no equity.
And that's because it's a Chapter 13, not a 7 or 11.
That's because
right?
it's a Chapter 13. Exactly.
Okay.
Now, what happens with the chapter, the problem is that if your house under that scenario was worth $101,000, in other words, and the first lien was $100,000, your house was worth $101,000, and there was a $100,000 junior lien, you would not be able to strip that lien because the creditor, the second lien holder, has, believe it or not, $1,000 worth of equity. So it's only if the second lien holder, third lien holder, whatever your lien holders are totally unsecured that you are able to strip off these liens.
Now, Jeff,
but that is still a valuable tool.
I want to talk a little bit about how that's determined. We have another break, so let's go to our break, and then we'll come back to explain more detail of that, which I think a lot of people would be interested in.
Sure, absolutely.
Voice America Business Network, the bottom line in business.
At Intuitive Strategies, LLC, we provide services to our clients that help them develop a strong education in business. And we also help them to develop a strategy that will allow them to turn their skills into a profit, protect their business and personal assets, and plan for a successful retirement. Our consulting and structuring services include business analysis, budget analysis, management analysis, ability to raise capital from investors, tax planning to minimize tax liability under code, as well as legal structure to protect business from frivolous lawsuits. Intuitive Strategies also provides document preparation services, such as business structuring documents, documents that establish an entity, management agreements, retirement plans, estate planning, wills, and trusts. Let Intuitive Strategies help you with your business. Visit intuitivestartup.com or call us in Tucson at 520-425-8759. Visit intuitivestartup.com today.
From the boardroom to you, Voice America Business Network.
You are listening to Strategies for Financial Survival with your host, Michael Figueroa. If you have a question or comment about the program, please send us an email to support@intuitivestartup.com. That's support@intuitivestartup.com. Now, back to Strategies for Financial Survival.
Okay, so we're talking to Attorney Jeff Neff regarding a strip down on debt for your home. Jeff, one of the things, as you pointed out, was that if the property was valued at 101 and the first is 100 and the second is 100 and there's a $1,000 equity that you cannot strip the second. So how is a value established?
Well, in order to create a lien stripping situation, you have to file a lawsuit within the bankruptcy. That's called an adversary proceeding. And you file that within the bankruptcy. It's heard by the same judge who's controlling the bankruptcy. And it's sort of a mini lawsuit against the creditor. And what you have to do is you have to hire an appraiser to be able to deal with the value of the property. And the other side, if they disagree with you, may hire an appraiser and say, no, the value is not 70, it's 170. And so you may need to present evidence to the bankruptcy court. Now, I might add that bankruptcy courts typically are lean, let's call it gently, toward the debtor. They are not executioners of creditors. They're not against creditors, but they do lean gently toward debtors. And you would probably have a very favorable hearing. It's not an uphill battle. It's a very fair fight to establish the value of the property. So you do need to value the residential property with an appraisal. You need to go present that to the judge, and then the judge will decide if the lien is stripped or not. If there's any resistance by the junior lien holder. However, I'll also say this, that in many cases, the junior lien holders figure they're washed up anyway, and they don't respond. And that means that you get the relief you want without having to go through any trial or any hearing on it.
Very good. Now, Jeff, explain a confirmation plan process, how that works for a Chapter 13, which again is primarily people that have wages that they are earning.
If you have any kind of regular income, you can file for Chapter 13, so long as that regular income is enough to give you disposable income to pay your creditors. Now, I should tell you that that's called the means test, in other words. And the test for net disposable income is determined by Internal Revenue Service averages on tax returns in the area in which you live. So the cost of living would be higher in New York City or Los Angeles or other major cities, and more people would qualify for Chapter 7. Less people would qualify for 13. But here in Tucson, cost of living is somewhat lower than New York City. More people qualify. So that's how you determine that.
Okay. So what timeline is this process to...
First of all, if someone comes to me and they have a house, a car, and they have this is a very common scenario. Many times people will have a house and a car, and they will have decided they would like an RV. And RVs have gone down dramatically in value. And I had a young man, an older gentleman, military retiree, in my office the other day, literally crying because he had lost the RV and they were taking an $80,000 judgment against him. He said, "It's not my fault. My wife got sick." So he couldn't pay for the RV. He had to devote expenses to his wife, care, and he was had a huge judgment against him for the RV. So we looked at that. He can definitely qualify for a Chapter 7. We went in and were able to relieve him of that debt almost immediately. When you file any bankruptcy of any chapter at all, you have to fill out forms. Now, in our office, that is Neff and Griffith in Tucson, Arizona, we have simplified forms that we help and guide you through. We also have to pull a credit report for you to make sure that we have a certain amount of due diligence that we need to do, or I call due diligence really verification. Then we make sure that you've listed all your debts, your creditors have the right address, file a petition with the court. That's all done electronically. Then in about 30 to 60 days, depending on the court schedule, you get a hearing where you have to go down and appear before a trustee. It's not the judge, it's the trustee. And all you need to state at that hearing is it's basically a name, rank, serial number. Your name, how long you've lived in the jurisdiction, the schedules are true and correct. And these are, and you might have to answer a question about an asset that the trustee would have. Many times it's, well, you've listed a car. How much do you think that's really worth? Tell me about the condition of the car. Because if the car is in mint condition, it'll be worth more. So it's a very quick hearing. There's probably 5 people in a half an hour period. So you can see that it's going to take about 5 minutes for each one of them, and that's how much the trustee is going to have. So it's not an interrogation. And after that, you don't have to do anything. You are discharged. Now, one thing I didn't mention, and again, I should mention this, is to file any chapter of bankruptcy, Chapter 7 or 13. You're required to take a mandatory debtor education course. The quality of the course, the content of the course is the same. Quality can vary. It can be taken on the internet. And basically, what it tries to do is help people not get in the same predicament again. I don't know if it's successful or not. I don't see any statistics on it. But let us hope that it is an attempt to keep people from repeating the same mistakes. In a Chapter 7 bankruptcy, you may not file for a Chapter 7 bankruptcy more often than once every 7 years. But that's a full 7 years, so it really amounts to a full 8 years from beginning to end. And you may not file, and you may file, however, as many Chapter 13s as you need to. There is no limit on those. And many times you'll see people go in and file a Chapter 13 and then abandon it, come back later and file another 13 and pay off the rest of their debts that way.
Very good. Jeff, we're going to be coming up on our last break. I'd like to touch a little bit on Chapter 11, why someone would do an 11. I know that it's primarily for businesses. And then some more stories of what you have experienced so that you could tell people what to do and what not to do and not come into you after they've done the problem and then you have to bail it out. So let's go to our last break here, and we'll be back in a minute.
Whether the market's up or down, or if you're looking to improve your portfolio, our experts are ready to talk to you. Call now. Toll free, 866-472-5790. That's 866-472-5790. Voice America Business Network. At Intuitive Strategies, LLC, we provide services to our clients that help them develop a strong education in business. And we also help them to develop a strategy that will allow them to turn their skills into a profit, protect their business and personal assets, and plan for a successful retirement. Our consulting and structuring services include business analysis, budget analysis, management analysis, ability to raise capital from investors, tax planning to minimize tax liability under code, as well as legal structure to protect business from frivolous lawsuits. Intuitive Strategies also provides document preparation services, such as business structuring documents, documents that establish an entity, management agreements, retirement plans, estate planning, wills, and trusts. Let Intuitive Strategies help you with your business. Visit intuitivestartup.com or call us in Tucson at 520-425-8759. Visit intuitivestartup.com today. Up-to-date business and financial news. Call now and get the financial information you need. 866-472-5790. 866-472-5790. The experts are here. Voice America Business Network. You are listening to Strategies for Financial Survival with your host, Michael Figueroa. If you have a question or comment about the program, please send us an email to support@intuitivestartup.com. That's support@intuitivestartup.com. Now, back to Strategies for Financial Survival.
So, Jeff, continue on with what we were talking about.
Absolutely. Well, I think I'd like to tell people what we'd like at Neff and Griffith here in Tucson, Arizona. When people come into us, it's best if they've done a little bit of thinking about this beforehand. We do offer some complimentary consultations or low-cost consultations. Many times you'll find people come in and they've, let's say, hawked the automobile, or they borrowed money against their house when they didn't have to, or they paid money on a debt when they should have put that money into a retirement plan or an IRA. And it's really heartening. I mean, I have not seen any person in my practice in years at all that was out to defraud their creditors, get around them, abuse the bankruptcy code. What I see is people who've had tough times and tough breaks and tough problems to solve. Like the man I was telling you about, who was a military retiree, whose wife got sick and bought the RV, and then she got impossible for her to use it, and he had to lose the RV. I mean, it's unfortunate situations. It's things that shouldn't happen. It's calamities. And that's why the bankruptcy code can be helpful to you. But if you can anticipate a calamity and talk to a lawyer beforehand, don't go right up to the last minute. It helps us plan these things. And it can be so much softer a landing. And you can exempt so many more assets if you will talk to us beforehand, rather than running up those credit cards or having problems with automobiles where you sell one and you can't exempt it. So that's very important if you plan. Now, I can move to a little bit to a chapter 11 here. I see we're coming up to the end. This time has really flown. It's pretty amazing. Chapter 11 is really one of those, it's the most difficult form of bankruptcy there is. You have to have enough money to sustain the Chapter 11, and you have to meet many requirements to confirm a plan. You have to basically file, and oddly enough, Mike, Chapter 7, 13, and 11 require the same schedules. The government asks you the same questions on every single type of bankruptcy. So a Chapter 7 debtor may be mystified by why they're putting so many blanks in it. It's because it's meant for anybody from Joe and Mary Smith to General Motors. That's the same thing that they would file. And now, it's typically a business reorganization, but it can be adapted for individuals. There are provisions in it. If you have more than $1 million worth of debt, you're not entitled to a Chapter 13. You've got to flip to a Chapter 11. Basically, when you have a Chapter 11, you are in charge. There's no trustee appointed, but you have to file a plan and a disclosure statement and get that disclosure statement approved. Disclosure statement just tells your creditors what's going on. The plan tells your creditors how we're going to cure this problem. And then you have to meet a few requirements under what are called Section 1129 of the Bankruptcy Code. And those requirements are, first of all, the plan has to be feasible. You cannot propose to make $1 a month payments on $12 million worth of debt. You will be asked to please exit into a Chapter 7 if you're going to do that. The next thing is you have to have one of your creditor classes vote for you. And because there's open voting on the plan, and as long as one creditor class votes for you, you can get your plan affirmed. The third thing is you have to meet a liquidation test. And that is, no Chapter 11 plan can be confirmed if the creditors would get more money in a Chapter 7. That's usually easy to show, that the creditors will get more money in a Chapter 11. But you have to be very, very careful in a Chapter 11 because it's complex, it's expensive, and it's aimed at businesses. So if you have a small business it really doesn't work for you. But I would like to mention that I do have pending right now a filing for a bankruptcy of a restaurant. And this is a small restaurant owned by a couple in their own names. There's no LLC or Inc. As corporation involved. And they are perfectly capable of settling their debts, and I can show regular income from them. I can show what it is. And the problem they have is that they got into trouble with the IRS and the sales tax. So as long as we can keep the IRS current through the Chapter 13 and over 5 years pay back the other creditors, we're fine. So it's and a Chapter 13 does not require anyone to be convinced to vote for it. It's automatic under the Bankruptcy Code, and I might say many, many, many times you do not require a hearing on it. You can confirm the plan by stipulation, and that's a fancy lawyer word for agreement between the parties. So, Mike, do you have any wrap-up questions here?
Yes. I just want to tell maybe a war story or two. I had a client that I remember they were doing they had a foreclosure pending on their home, and the typical thing is wait until somebody finally said, oh, I can stop the foreclosure, which is happening tomorrow, and they run in, they filed a bankruptcy, and in that case, they did not think through what they were doing. So $25,000 in their checking account, savings account was there. Some diamond ring, engagement ring worth about $40,000. Some oil leases they inherited, and then in the middle of that, just before I should say that happened, a aunt died, and the debtor was a part of the estate, and so they lost all of that, and they got the stay on the bankruptcy approved for the house pending what are called adequate protection payments. So do you want to explain a little bit of that and embellish a little bit of what you've seen so that people understand this and don't make stupid decisions?
Well, yes, as I said, many times people are in a state of denial. And that's the first stage, I suppose, of grief, if you read any books on it. You deny that things have happened, and then you have to go through several other stages. The best thing to do is get over denial in a hurry. Okay, this is a problem. I see it coming. I'm going to consult with a lawyer. The worst thing you can do is to completely go into denial about the whole thing, and then it happens and it overtakes you. Because there can be planning done to save certain assets or transfer their value or stave off bankruptcy. Now, I am not talking at all, and I want to make that very clear, about fraudulent conveyances or anything like that. That's not what lawyers engage in. Can't hide assets. There are no Swiss bank accounts, and I'll put that in quotes, bank accounts. You have got to be extremely careful of that. And I will not participate in that. However, there are legitimate ways of helping people in bankruptcy that will overcome some of these problems. So I would urge a consultation immediately. There are people who I've consulted with who I've found ways of negotiating off. I had a gentleman that had quite a good income. We could qualify him under Chapter 7 because his debts were extraordinary. But what I was able to do with him, which is great, is I was able to bargain off the second mortgage on his house and legitimately pay them off. He's got his house pretty much on par with what should be with the value of the house. He didn't gain equity. He gained $100,000 of equity in the house by paying off the second lien. then on each of the other creditors, we were able to make smaller settlements on each one of them. And that he was able to do sort of a private Chapter 13 rather than having him exposed in full to a 13, perhaps lose his office building or other assets. So there's things short of bankruptcy that you can do to help.
Jeff, thank you. We're running out of time here. Let me have you once more tell how people can contact you. And again, I want to thank you for being able to be here.
Absolutely. Thank you very much, Mike. It's been a great privilege to talk with you about bankruptcy. Again, I'm Jeffrey Neff, specialist, Tucson, Arizona, law firm of Neff and Griffith. NeffLawAZ.com is our website. Go visit it. Or if you want to give us a call, 520-722-8030. Thank you very much.
Thank you, Jeff. And we will see everyone for our next show coming at the same time on Wednesday.
Thank you again for tuning in to Strategies for Financial Survival. Please join host Michael Figueroa again next Wednesday at 12 noon Eastern Time, 9 a.m. Pacific Time on the Voice America Business Channel. Until the next show, survive and succeed.